Okay, so welcome to today's podcast. It's Friday the 13th in January. Trying to establish a bit of a format to these things. There's been a lot of action at the Board of Pardons, and so part of what I want to review is an update about the Board of Pardons, and then go into a deeper dive about expungements and what can be cleared by expungement and when and what the process is. And then I'll wrap up with a couple of stories that came in during the week. So moving right into an update about the Board of Pardons. First of all, let me be clear, because occasionally I get calls and people say, "Are you the Board of Pardons?" Because my company is Pennsylvania Pardon Services, doing business as Record Eraser, also doing business as PA Pardon and Expungement Services, LLC. So instead of using the long name, we use PA Pardon Services. I am not the board, but my practice is limited to filing pardons and expungements throughout Pennsylvania, and so I'm in weekly contact with the Board of Pardons, and I have several cases pending. I have hundreds of applications pending at the board over the past 10, 15 years, and they have quite a few now that I'm waiting to work through the process. So, an update about the Board of Pardons. It has been an exciting year. At the end of 2022, as you know, it was an election year. Governor Wolf will be replaced by Governor Josh Shapiro, and Governor Wolf's last day is January 17th. So Josh Shapiro is being inaugurated in the middle of January, and he will sit as the governor. Now, this is actually good news because Josh Shapiro is leaving the Attorney General's position, and as the Attorney General, he is one of the 5 seats on the Governor's Board of Pardons. The Lieutenant Governor sits, the Attorney General sits, Department of Corrections sits, a psychiatrist sits, and an advocate for the victim sits. Those are the 5 board members, and Josh Shapiro has now moved from having a seat as the Attorney General to being the governor, who is the ultimate person who decides whether somebody gets a pardon or not. So Governor Wolf has, in the past 8 years, granted thousands of pardons, and currently I think he has about 300 to 500 pardons that seem like they're ripe to be issued. So I don't know if they were delayed by the election cycle or exactly why, but I'm expecting hundreds of pardons to be issued before he leaves office. And don't forget, every pardon needs an expungement. We'll go into that more later. So Josh Shapiro will be governor, and the lieutenant governor is Austin Davis. So Austin Davis is new. He was the lieutenant governor running mate with Josh Shapiro, and he was elected. I don't know a lot about Mr. Davis. He will sit on the board as somebody who has not been previously on the board, and in fact, he will chair the board. So the Lieutenant Governor Davis will now be the chairman of the Board of Pardons. And I don't think that's a reason for concern either, because frankly, throughout the government and certainly on the Board of Pardons, the dignitaries and the officials and the appointed people that we're talking about have the real power and the real duty to review these applications and give them all their attention. But the staff of the Board of Pardons are the ones who are researching them, vetting them, putting forward all of the documentation about the processes and procedures that lets the Board of Pardons move forward with what they're basically going to do is review them, have a vote to see if they get 2 out of 5 votes in order to go to a merit review, and then the merit review where the person is invited to do a presentation, and after that you need to get 3 out of the 5 votes. And if you get the 3 out of the 5 votes, then your pardon goes to the governor, and he's the final vote, and if he issues the pardon, then you need an expungement. Okay, so the former First Assistant Attorney General, Michelle Henry, since Josh Shapiro left the Attorney General's office to become governor, his first Deputy Assistant Michelle Henry is going to take the Attorney General's position on the Board of Pardons. So now we have Lieutenant Governor Davis, we have Acting Attorney General Michelle Henry filling those 2 seats. The other 3 seats will remain the same. I think the new board will start sitting in January. They're obviously going to have a backlog of cases to go through, which they will proceed to review in the first quarter, February, March of this year, as well as the second quarter. So that's another piece of the update. The Board of Pardons also wanted to release an online website where you can file your pardon application online instead of completing paper applications, as my office and I have been doing for the past 10, 15 years. That will be a welcome change when it happens. It has been put off from an intended launch of January 9th, 4 days ago, to being the first quarter, sometime in the next month or two. We're hoping that the Board of Pardons can launch their online website. What does that change? To my practice, all it changes is using less paper. I will still need to write off to the clerks of courts to get all of the official criminal records that the Board of Pardons wants to review. Instead of photocopying them, they'll be uploaded. Okay, but the official records will still need to be requested. The answers will still need to be designed of explaining why the crimes occurred, each of the crimes. There might be one crime, there might be a series of crimes, and the candidate has to give a good explanation, accepting responsibility for why the crimes occurred. And then also the candidate has to write or present or offer an answer of everything they've done with their life since the crimes and why they're a good candidate and why they should be considered for this official recommendation for forgiveness. So that part of the work doesn't change. We're still ready, willing, and able to request the records, help people with their answers. Once the pardon application is filed, whether it's filed by paper or whether it's filed online, it begins the 2-year review process, and if somebody's using my services, we track the application and give them advice and representation for any hearings or interviews they have along the way. So for content this week, what I wanted to do was take a deeper dive into expungements. Expungements are petitions that are filed in the local court, the county court, the Court of Common Pleas. Pennsylvania has 67 counties, and every one of them has a Court of Common Pleas. Expungements are orders from the court that tells the state police and all of the police agencies and investigating agencies to expunge or destroy their records of a given incident. So the order from the court is ultimately the expungement order. It's what's desired. It's what clears a record in Pennsylvania. The process of getting the expungement order is that a petition is filed. A petition is nothing except a piece of paper, maybe 6 to 9 pages of paper and exhibits, and it says why the person is entitled to get the expungement and the facts set forth therein, as we say, about what the person did, when they did it, what the charge was, and why they're eligible for expungement. And we enclose a copy of the attached order that we want the judge to sign, and that's an expungement petition filed in the local Court of Common Pleas to clear a criminal record for a conviction that was obtained in that county where the petition is filed. Now, expungements are governed by statute, and so the legislature back in the day wrote a statute saying these are the things that can be expunged. Now, they're not always automatically expunged. In fact, they're not automatically expunged with some disclaimers, but they're eligible for expungement. And so those things are delineated. We know what they are. Lawyers know what they are. If you ask for an expungement of something that's not listed in the statute, a judge is going to deny it, and they're not going to spend a lot of time explaining why it's denied. So I have actually had people call me and say, I filed an expungement petition and the judge denied it. Well, what were you trying to expunge, I ask? A felony or a misdemeanor conviction? Yes. Well, a judge can't expunge a misdemeanor or felony conviction until it's been pardoned by the governor. Did you get a pardon? No. I said, okay, well then you asked for an expungement for something that isn't expungible within the statute, and that's why a judge just wrote no. So I'm going to go over, I call them 7 things that can be expunged, and spend a little time explaining each one. But first I'm going to mention all 7 of these things that are eligible for expungement. Juvenile adjudications, summary offenses that are over 5 years old, an underage consumption summary offense once the offender has reached the age of 21, charges that have been withdrawn, dismissed, or null-prossed. Similarly, a DUI case or any other case that got ARD as a disposition is expungible. A misdemeanor or a felony conviction if you're over the age of 70. So here's the exception. If you're over the age of 70, you don't need a pardon, but everybody under the age of 70 that has a misdemeanor or felony conviction does need a pardon before the expungement. And finally, number 7, anything that has been pardoned by the governor of Pennsylvania is eligible for expungement. So those are the 7 categories, and now I'm going to explain each one after I explain what the process is. So this process is going to apply to all the different 7 ways of asking for an expungement. So the process is a petition is filed in the court where the conviction or the adjudication is. Let's back up a second to basic civil procedure, basic social studies. A defendant coming forward to ask for something is the defendant. Where in America we follow the rules of law, there's always 2 parties. The party in any criminal matter, the plaintiff is always the Commonwealth. It's the Commonwealth, it's the state versus so-and-so. So if and when you were charged with a crime, it was the Commonwealth prosecuting you. The Commonwealth is represented by the district attorneys, the assistant district attorneys that represent the state and help the police officers, who are the agents of the state, to prove their case. The defendant is represented by a defense attorney who is his zealous advocate, who challenges the evidence and goes to court with him and tries to either prove that the state does not have sufficient evidence or that there's some other kind of factor that should mitigate the case or lead to some other disposition. These 2 parties always go in front of a judge. The judge is the neutral, detached person who, a common pleas judge in Pennsylvania, is always a lawyer, always an experienced lawyer, and the judge sits there and looks at the pleadings, this is what these things are called, the pleadings from the district attorney, the pleadings from the defense. If they need to gather facts and evidence on record, they take testimony, and then they listen to one side make an argument, they listen to the other side make an argument, and then the judge decides what's going to happen, whether it's an argument about the admissibility of evidence, whether it is an argument about the sentencing guidelines and what sentence a defendant should receive, whether it's an argument about bail and whether somebody should be let out of jail or not, or whether it's an expungement petition and somebody saying my record should be cleared. It always goes through the same process, and this is that process for expungement. The expungement petition is filed by the defendant saying, I have a reasonable argument that my record should be cleared. It's filed in the court. When it's filed in the court, the district attorney is served with a copy of it because he's on the other side. The district attorney has 30 days to take a position, and so it probably gets delegated to an assistant district attorney, and they research the case. The the case would be, we're entitled to this expungement because of one of these 7 reasons. And so the assistant district attorney would read those reasons, jump into their database to see if there's been another conviction or something that would negate the request for an expungement. And usually, I would say 80–90% of the time, the district attorney joins in the petition for expungement or takes a position of non-opposition, which is the same as agreeing to it. They say the Commonwealth is not opposed to this petition being submitted by the defense. And in that case, the judge will get it without an objection from the district attorney. The judge will most likely sign it, and now you have a signed expungement order. The process after that is that it goes from the judge to the clerk of courts. There are some differences in the counties of Pennsylvania, but the clerk of courts basically serves all the people that had records, whether it's the district justice, the police, the Pennsylvania State Police, the county detectives, the police department that brought the charges. Everybody receives this expungement order with an order to destroy or expunge those records. The primary record that we're concerned with are the state police. And so the state police, they are the official repository or keeper of the records of all criminal matters in Pennsylvania. And when the state police get a copy of an expungement order, it takes them 2 or 3 months to process the order, get into their database, erase the order, destroy it, make whatever notes they make, and then send an affidavit or some kind of confirmation to us that says the record has been destroyed in agreement with the order from the judge of the Court of Common Pleas. And then we know the case is resolved. A secondary process that goes on behind that is the FBI would update their records from the Pennsylvania State Police. It's not clear how quickly that happens, but the FBI at some point would receive notice of the fact that they are to destroy their records. And then another secondary process is how this information ends up being disseminated to the various national background research companies that are required to update their records to comply with the expungement order, but out there in the internet and the vast archives that are out there, there's no guarantee about how quick that happens. But the focus of my work is presenting the expungement petition and making sure the signed order is sent around and that it's completed. If the district attorney opposes the petition for some reason or another, then he would ask the judge for a hearing, and then the judge would order an expungement hearing when the petitioner, that's the attorney and the defendant, would have to go to court in order to carry the burden of proof of why they're entitled to this expungement. The Commonwealth would be responding in a sort of defensive position and trying to prove why they think you're not entitled to it, and that's called a Wexler hearing. If and when a Wexler hearing is needed, it is the defendant putting forth name, age, date of birth, what happened in such and such a day, and why, how they've lived their life since then, and why they're entitled to the expungement petition. Of course, they would be responding to questions from their attorney, walking through all of the factual allegations that need to check off the boxes on the expungement petition. The assistant district attorney would then get a chance to cross-examine, and then the judge would make a ruling. District attorneys and judges and defense attorneys don't like to waste time having hearings when there is no issue of fact or law. If there is no issue of fact, what is said is true, and if there is no issue of law, you're either entitled to this or you're not, then the district attorney doesn't want to waste the court's time, the court doesn't want to have its time wasted, and the defense attorney doesn't either. So usually if the district attorney reviews an expungement petition and they have some question or issue, they call up the defense attorney, or frankly, I'm always calling assistant district attorneys to say, hey, have you reviewed this petition? They frequently don't look at them until the week before the hearing's scheduled. So the petition's filed, the DA gets notice of it, maybe the DA asks the judge to schedule a hearing date a month or two in the future, and then the district attorney doesn't really get assigned to the case till maybe a week or two before the expungement petition. I've been calling an assistant district attorney in Montgomery County since last week, and I got a call back yesterday to decide if I need to go to court this afternoon at 1:30. So I'm thankful I got the call. I'm going to follow up with her this morning. She wanted to verify the facts alleged in the petition, and I suspect that she's going to say, we have no opposition, you don't need to come down here. But that is some of the timing that goes on. The paperwork's very slow and methodical, and sometimes the human communication about whether we actually have to go to court is a little bit last minute and a little more rushed. So that's the procedure for expungements. All right, of the 7 expungement petition reasons that you can file, the first one is juvenile adjudication. Just a really quick discussion of language here at the beginning of juvenile adjudications. Juvenile charges are crimes brought against people that are under the age of 18. Because you're under the age of 18, you're prosecuted under the Juvenile Act. The Juvenile Act does not want to use the same language in prosecuting children that it uses in prosecuting adults. So whereas an adult would be charged with a crime, a juvenile is charged with an offense which, if proven against an adult, would constitute the crime of. I kid you not. There's a dance. If an adult were being convicted of a crime, the juvenile is adjudicated delinquent of the crime. It's the same as a conviction, but it's a juvenile adjudication. The trial would happen for an adult. A juvenile adjudication hearing is held for a juvenile. So anyway, juvenile charges against someone under the age of 18 are governed by the Juvenile Act. And the Juvenile Act basically says there's some ins and outs and some nuts and bolts and some details that if you're over the age of 21 and you've been out of trouble for 5 years, that you can petition the court to have your juvenile adjudication expunged. This usually happens because a juvenile adjudication for a serious felony, whether it's robbery, aggravated assault, kidnapping, things of that sort, if it's a felony 2 or felony 1, even if it's a juvenile adjudication, it's going to show up on an FBI background check and a Pennsylvania check for employment. So most juvenile cases don't show up for background checks, but felony 2s and felony 1s do. And so that's when somebody comes and says, hey, can you get rid of this juvenile adjudication? Also note, let's say you got charged with a crime when you're 16 or 17, and now you're 22 and you're trying to get employment and you want to file an adjudication. Let's say it was an aggravated assault where someone bled or you did some time in a juvenile facility. The district attorney, remember how they get a copy of the petition? They're always going to check with the victim. They're going to check with the Office of the Victim Advocate, and the victim might say, well, no, I don't agree with that. Now, the victim's opinion doesn't control what happens, but it's going to be taken into consideration. The district attorney might say, this is where a Wexler hearing might be appropriate. A district attorney might in effect say, Judge, I want you to schedule a hearing. And at the hearing, the defense would say, Judge, here we are. It's been more than 5 years. There's been no offenses since then. Here is Tom. He's going to college. He's studying. He's working hard. He needs this off his record so he can go on with his life and increase his earning capacity. And the district attorney might say, well, that's nice, but this crime is especially nasty, and someone was wounded, and they still bear the scars to this day. And this isn't a case where we think the judge should issue an adjudication. So this gets into what's called the Wexler balancing test. The judge sits there in the middle of the seesaw with the district attorney saying serious crime was only 5 or 6 years ago, so that's what the law considers actually relatively recent. And the defense attorney and the defendant say, but Judge, I've learned a lot, I'm now employed, maybe I'm married, maybe I even have a child I'm trying to provide for. This is bearing an undue hardship to me. And so that's what the purpose of a Wechsler hearing is to give the judge the seesaw or the scale of justice for the judge to make the decision. Technically, when the judge makes the decision, the district attorney would be able to take an appeal if they really didn't like the decision. I don't think they normally would, but again, it all depends on the case. It's important to remember that 90%, maybe 95% of juvenile adjudications are routine criminal trespass, burglaries, stealing PlayStations, simple assaults, disorderly conducts, things that happen in school all the time. They're not these exceptional cases where someone bled or has a scar. I just have to give that as sort of an extreme example of when a district attorney might oppose an expungement petition. So to circle back, a juvenile adjudication can have a juvenile expungement petition filed on it after 5 years of law-abiding conduct if the person's over the age of 18, depending on what the district attorney's position is. And again, the defense and the district attorney would be trading phone calls and emails and talking about things ahead of time to try to work this out. An interesting side note is the fact that it's almost more difficult for a defense attorney to get juvenile records than for the juvenile to get them themselves. So sometimes, depending on the county where the adjudication is, especially if the person still lives there, I'll ask them if they can go to the juvenile record division and ask for a copy of their juvenile records so they can forward them to me. Then I can review them and give them good advice about whether we should file the petition, whether I think we're going to have a hearing or not, and quote a fair fee for whatever's going to happen. Some counties we actually can enter our appearance to represent the juvenile and request the records, but juvenile records is an especially sticky area of record requesting, and that's what I have to say about that. The second area of expungements covered under the statute are summary offenses that are over 5 years old. A summary offense, and these are pertaining to summary offenses written under the Crimes Code, a summary offense would typically be something like retail theft, also known as shoplifting, harassment, which is unlawful striking, kicking, or shoving, disorderly conduct, which can be a wide variety of behavior ranging from lewd and lascivious to nasty language to just being disorderly. It's a catch-all for the police for any kind of unruly behavior. Public drunkenness. So basically what I'm looking for under this statute is I want it to be written under Title 18, so it's a crime. Most crimes are misdemeanors or felonies, but small crimes are written as summary offenses. They're almost like traffic tickets. They only have like a $300 fine. There's usually no jail time involved. People tend to just plead guilty to them. Don't do that. Talk to an attorney. It's easier to avoid a conviction than to wait 5 years after a conviction to try to clear it. But a summary offense after 5 years of law-abiding behavior can be petitioned to have it expunged. If everything I've said is true and there has been law-abiding behavior and it's a single summary offense, then the expungement should go through according to the process that I covered, and then the record will be cleared. One of the sticking points about these cases are sometimes people have more than one summary offense. Sometimes the police believe, well, you're charged with a misdemeanor 2 or a misdemeanor 3. You could get a year or 2 probation. So I'm willing to reduce your charges, but I want you to have 2 summary offenses. I want you to have 2 harassments or a harassment and a disorderly conduct. Now you have 2 summary offenses. So in the language of the statute says you can have a summary offense expunged after 5 years of law-abiding behavior, but it doesn't say you can have 2 expunged. So some counties, the district attorneys are very reasonable and they look at it and they just say, look, this is a summary offense. Go ahead, file for both of them. We're just going to agree. Other counties, I take the procedure of filing 1 summary expungement to get that one gone, and once it's completely disappeared, I circle back to expunge the second one, because now they're not sitting there as twins. One goes away and then the other goes away. I don't know if I need to do that, but what I don't want to do is file on both of them and have the district attorney say, oh, well, now we need a hearing because you're trying to get both expunged, but you're only allowed to get one expunged. We could go to a hearing in front of a judge, and based on reasonable argument, a judge might clear both, but he might not. And then the county and everyone knows that I tried to clear both. Then can I circle back and clear one? Maybe. I don't know. So I file on one and then the other. And that's what I have to say about summary expungements after 5 years. You have to have 5 years of law-abiding conduct. Can you get a speeding ticket during those 5 years? Sure. No other criminal conduct. What if I get a compulsory attendance at high school? I'm not worried about that. Just no criminal conduct. Thank you. I'd like to cover which of the summary expungements can be filed on people who have underage consumptions and turn 21 years of age. This is a great subsection of the expungement statute that makes great sense. The legislature passed it, and it says this: if you were charged with underage consumption under Section 6308 of the Crimes Code for possessing malt or brewed beverage when you weren't 21, and you got a summary conviction for that, as soon as you turn 21, you can file for an expungement, and a judge will sign the order, the district attorney will agree, and you will get that off your record. It does not have the requirement of no 5-year period with law-abiding conduct. The statute simply says if you have an underage consumption and you're over the age of 21, you're entitled to an expungement. I've never run into a problem with those, and so that would follow the normal expungement procedure in the county of the underage consumption conviction. Be careful of the fact that sometimes police or attorneys think they're doing you a favor, and they'll switch that underage consumption to a summary offense like an ordinance under the local ordinance code of having an open container or something like that. That's not a charge under the Crimes Code. That's not covered by the underage consumption, can be expunged after you turn 21. So you might have to wait 5 years to have a local ordinance expunged. It's not even clear if that local ordinance would be covered by the expungement statute. So I'll save that for a separate video. Thank you. The next section of charges that are eligible for expungement under the expungement statute are charges that have been withdrawn, null prossed, dismissed, or not received any kind of finding of guilt. So, typical scenario would be a husband and wife get into a fight, they're charged with simple assault against each other, maybe a misdemeanor 3 simple assault. They go to some counseling, they reconcile, they decide to stop having so many fights, and they go to the preliminary hearing. Maybe they both have defense attorneys, and they talk to the reasonable police officer, and they say, officer, these people don't have any prior record. They had a fight. It's a stressful time in the economy. They are going to counseling. They both don't want to go forward and testify against each other. Can these charges be withdrawn? If the officer agrees, then the matter is withdrawn by the Commonwealth. And so after charges have been withdrawn by the Commonwealth, then an expungement petition can be filed, because whether it's fair or not, the fact that the husband and the wife have been charged with simple assault will remain on the public record. It will show no conviction. It will show the charges were withdrawn, but it will show as a simple assault. And unfortunately, we all know that employers and just general people these days, if they see an allegation, they think it's a conviction and it's not, and then you end up explaining something that should never need to be explained. That's why non-convictions need to be expunged. Now, the same case could go in front of a judge for a hearing, maybe because the officer won't agree to withdraw the charges. So the judge would start a hearing and call the wife to testify against the husband, and she might say, I don't want to give any testimony because I can't give any testimony without giving evidence against myself. And the judge might say, well, okay, well, then you're excused. And then the husband would be called and asked, can you give testimony against your wife? And the husband might say, I don't want to give any testimony against my wife because I can't give any testimony without it being used against me. And the judge might say, okay, well, then you're excused. So the Commonwealth brought the case, and I've heard the fact that there is no evidence, and so I'm going to dismiss the charges. So the dismissal comes from the judge of the court, not the Court of Common Pleas. The dismissal comes from the magisterial district judge because the Commonwealth couldn't support their burden of proof, but wasn't willing to withdraw it. Nonetheless, there's no conviction of guilt, and so that charge can be expunged upon petition. Another subcategory is null prost. I get a lot of questions about this because it's a weird word. Null pros, nolle prosse, nolle prosequi. It's a Latin phrase meaning not prosecuted. It means that the Commonwealth has the burden of proof to move forward. They didn't move forward for whatever reason. The case was null prost. Maybe the Commonwealth isn't comfortable withdrawing the charge, and instead they say we're not prosecuting it. There's very little legal distinction there. It results in a non-conviction, and therefore it's eligible for expungement. And now I'm going to segue right into number 5, which is ARD. ARD is a specific dispositionary program that stands for Alternative Rehabilitative Disposition, and it was created primarily because DUI is America's favorite crime. And plenty of fine, upstanding people go out and have some wings and some beer and get pulled over by the police, and it's a first offense and they get a DUI. Back in the day of Andy of Mayberry, Barney would come over and maybe talk to Andy and maybe the charges would just go away. But in this day and age, you're going to get charged with DUIs. It all goes in front of the district attorney's office. They're very cautious because they don't want somebody getting away from a DUI and then getting drunk and killing a family of 5. And so what the district attorneys did was create this program called ARD. And if you get into the ARD program, and many counties, maybe all of them have it, it's a probationary period requiring you to do drug and alcohol counseling and a drug and alcohol evaluation and pay your fines and costs, and whatever probation is required, pay off your fines and restitution. After you complete that program, usually in a year, after that probationary period, your charges are dismissed, or more accurately, your charges are eligible for dismissal and then expungement. They frequently don't dismiss and expunge themselves. I think there's 2 counties that do expunge their own ARDs. Most of the others do not. And so if you had a DUI charge and you completed ARD, your charge is eligible for dismissal and expungement because it's not a conviction. And that's why it's its own subcategory, but also why it's sort of in the same kind of category as the null prost withdrawn or dismissed charges. The final 2 categories of things that can be expunged are my favorites because there's a lot of value for the same low expungement fee. So the 6th category is that if you have reached the grand age of 70, which I'm not going to call a grand old age, it's all younger people calling people over 70 old. I've known many 70-year-olds that are doing just fine and glad to be there. So if you've reached the age of 70, and even if you have a felony or a misdemeanor conviction for pretty much any crime whatsoever, most of these crimes were back in the day when you were in your teenage years or your 20s or even your 30s, or you even had a little bit of depression and got 3 or 4 DUIs when you were in your 40s after your first divorce, and maybe one of those DUIs is a felony 3. It doesn't matter. If you have been off of any kind of supervision for over 10 years, meaning your supervision of anything stopped before you were 60, and you're now 70, You can petition to have any misdemeanor or felony conviction expunged without the necessity of going through the 2-year pardon process. It's just green light to the expungement, written by the legislature. Thank you very much for holding out this olive branch to people that have lived and worked and paid taxes until they've reached the age of 70. So that is the 6th category. The 7th category of things that can be expunged is also one of my favorites. It is any misdemeanor or felony conviction that has been pardoned by the governor. So to all of the people that have misdemeanor or felony convictions, you have to be forgiven by the governor before you can file an expungement petition. So the pardon process is all covered in a variety of other videos. The pardon process is a 2-year process that starts with the completion of a pardon application that then gets filed and investigated and tracked for the next 2 years until you're ultimately given an invitation to do a presentation to the board. If you use our services, we handle all that prep and preparation for you. And once you get the pardon from the governor, then you can go to the county and you can ask for an expungement petition. You will not have a Wexler hearing. You should not need any kind of hearing. Forgiveness from the governor of Pennsylvania is in itself the reason for the issuance of the expungement. And then about 2 to 4 months after you file the expungement petition, your record will be cleared. One of the frequent questions I get is, Mark, if the expungement's what I need, why do I have to get the pardon? And the answer is, if you have a misdemeanor or a felony conviction, you can't get it expunged till it's been reviewed by the Board of Pardons and forgiven by the governor. And that's just the way it is. This is the part of the podcast where I like to read stories. These are stories that come into me every day and every week of people with a variety of different situations and factual situations. And I can do these presentations to you about these cold, hard, dried fact patterns, and they always work out nicely, but the stories don't always fit into those. And so if I go through them with some quick analysis, maybe, a couple of them speak to you, and so it is. I will never, ever disclose anybody's identifying information by phone number or email or fact pattern. So these are, to me, anonymous stories that share a similar factual basis, but I can get through enough of the generic details to let you know what they're asking about and what my opinion is. So this person was charged with a DUI in July of 2017. Wasn't able to do ARD even though it's a first offense. So previously I talked about ARD and how it's probation without conviction. What he has just indicated is that this is a DUI conviction. Now we know it's a misdemeanor conviction. Now we know it needs a pardon from the governor. I can sort of jump sideways and say, is a 2017 DUI ready to file for a pardon? It's currently 2023. With a 2-year review process, it's 2025. His DUI will be 8 years old. Unless he has completely quit drinking and has been on the wagon since 2017, I personally don't think the Board of Pardons is eager or quick to remove DUIs before that 10-year period has gone by. And so I might explore those questions in terms of the pardon, but that's not his question. His question has nothing to do with that. I've completed probation and the highway safety class and drug and alcohol treatment. I want to get my CDL for heavy machinery and the DUI is holding me back. So here's the thing. The CDL issues from PennDOT. PennDOT records can't be expunged. He didn't get ARD. He got a DUI conviction. PennDOT's not going to change their records. So however PennDOT's indication of that DUI is affecting his CDL is not going to be affected by my previous evaluation of whether he should file for a pardon to try to get the DUI off his criminal history. Yes, the DUI will come off his criminal history eventually, but that still won't necessarily help him with his issues with the CDL. And I think I will try to find an attorney that is expert in CDL matters and probably invite him to a podcast. But for right now, that's my answer to that question. 1992, delivery of controlled substance. Conspiracy to deliver in 1994. Also, a DUI. I can't find. Travels restricted to Canada. I want to start hunting. I want to find better jobs. Big price to pay for mistakes made when I was 18 years old. Okay, quick analysis. 92, delivery, that's a felony. 94, conspiracy to deliver is a felony. Just side note, every conspiracy is the same grading as every felony that was conspired. So there's no downgrading in the conspiracy just because you made the illegal agreement. If the agreement was to do a delivery, the delivery is a felony, the conspiracy is a felony. So 2 felonies from 92 and 94 and a DUI he can't find. That makes me think the DUI is a misdemeanor and it's over 10 years. It's probably been hidden by the clean slate law. So, first of all, good candidate. I like it. I think the felonies are ripe to file for a pardon from the Board of Pardons. I don't think that DUI is going to affect a thing. I think this guy, after the 2-year pardon process and the expungements that follow the pardons, I think he's going to be going to Canada. I think he's going to be hunting. I think he's going to get better paying jobs. It's just you've got to get started, because with a 2-year process, this is the beginning of 2023. You don't want to end up thinking about this again and saying, hey, did I file that back in 2023? Now it's 2025. You could be getting your pardon. So again, I always give a free consultation and a free evaluation, but this guy, I'm going to tell him I think he's good to go. All right, I have a message here that I was charged and pled guilty to theft. There's so many theft charges. They range from misdemeanor 3s up to felonies of the 3rd degree. There's so many. I was charged and pled guilty to theft in 1999. I like it already. Came home from a party and took a lawn ornament. Passenger threw it out the window in front of a police officer. I don't need to hear anymore. All crimes are not the same. This is what comes under the category of stupid, teenage, knuckleheaded, stupid fun. Is it a crime? Yeah. Is it a crime that should be following this guy into the 2020s? No. We know it's a misdemeanor or felony conviction, misdemeanor conviction, theft. He just needs to file. I think he's a great candidate. That's what I'm going to tell him. Here's a case I frequently get. I'll just do 1 or 2 more of these. The first couple of words are, had a mental health conviction under 302 back in 2010. Released after a couple of days. Okay. Yellow lights, if not red lights, are going off to me. Remember, my focus is removing old Pennsylvania misdemeanor and felony convictions through the use of pardons and expungements. This question is coming from somebody who wants to get his firearm privileges restored, which I understand and respect. His firearm privileges are not because of a criminal offense that he talks about. They're because of a 302 mental health commitment, which is a separate disability, which has nothing to do with a criminal conviction. I always refer these people to Alex Egner at Chipper and Egner, who I have a podcast with, who reviews firearms disabilities and mental health disabilities. It's a civil matter. There is a way of restoring firearm privileges after a 302 petition is filed, but that is not what I focus on. And other than knowing that I'm going to refer that case, that's all I need to read about that. Occasionally 302 people, they do have criminal convictions because if somebody is in such a stressful circumstance that they actually get committed. The police aren't usually far behind, and usually it's a couple of maybe wild and crazy actions that got them criminal charges before they get their 302. But in this particular case, they're only talking about a 302, And so that's my answer for that story. Very simple case came up next. Simple assault in 2013 and something, question mark, from 1991. I hope you can help. Thank you in advance. Green light, green light, green light. All I hear is that 91. All right, so simple assault from 2013. It's 10 years old as of now. By the time the board reviews it, it's going to be 12 years old. My review of simple assault is an assault. So we know the board and the police are going to take it seriously. All simple assaults are not the same. Some simple assaults are just because I scared you and I said I'm going to punch your lights out. And the police felt that it was bigger than a summary harassment, and it was bigger than a simple assault, misdemeanor 3rd degree, which is a really small simple assault. Maybe this is a simple assault M3. Maybe it's a simple assault M2. But punching somebody in the face and actually hurting them with the intent to commit bodily injury is a very small percentage of simple assaults. Most simple assaults are nonviolent. They're brought to get a person under control. And so depending on the factual circumstances, some simple assaults are brought by a wife against a husband because he had too much to drink and she got scared and she wanted to hold him accountable for his drinking. And so he ate the plea to the simple assault, got drug and alcohol counseling, and they're still married and they're living happily together with kids. So you can see how widely the facts can vary from case to case. This case, 10 years old, 2-year review process, unless this simple assault, notice it's not an aggravated assault. There's plenty of room above the assault category for aggravated for serious crimes where people got shot or bled or really hurt someone. Simple assault, M2, M3, 10 years old. I'm thinking this is probably a good candidate. I'm going to get into the details with him. This candidate indicated that they were charged in 2012 with retail theft from a Walmart. And the way this came about is they received a call from a police officer after they left, and the person cooperated with the police and said, "No, I still have the items. I forgot to scan them. They're in a bag. What do you want me to do?" And the police officer said, "Well, I want you to return them to Walmart and I'm going to charge you with a crime." This is not unusual. So it's a retail theft from 2012. It's a nonviolent theft offense. Could have been caused by mistake. The fact that she is saying she is innocent of the offense and wanted to return the stuff really doesn't matter for the purposes of getting a pardon. The point to me is that it's not the crime of a century. It was either a mistake or it was a long time ago. And in either case, it doesn't matter. I think this case is ripe for review by the board. On a side note, it sort of talks to me as a former prosecutor about how far America has gone down the path of having the police basically be collection agents for retail stores. And while I don't want the cost of retail goods to go up, and I know some people steal deliberately and methodically and deserve to be caught and prosecuted, I also know that there are a ton of people out there that make mistakes at the ring out line, and charging everybody with the same crime seems like overkill to me. But then again, this was back in the day, and what you need to do, maybe this is a side pitch for the fact that anytime you get charged with a crime, just talk to a defense attorney, find out if there's a diversionary program, and try to prevent this thing from becoming a conviction. Maybe I'll cover a couple of quick ones because I've been reading sort of the more complicated ones, but some of these are really quick. This guy here, this guy or gal here, had 2 nick bags of weed, was charged with a felony 3. So he didn't have much pot, but the police charged him with possession with intent. Very small crime, felony. I don't know how old it was. I'll find out what year it happened. But yeah, I think that's probably a good candidate. And if it's marijuana, it's going to get an expedited review in 1 year instead of the usual 2 years. Awful lot of people get charged with carrying a firearm without a permit or without a license. This person in 2000 was charged for carrying a firearm without a license. Charged originally as a felony 3, ended up pleading to an M1, a misdemeanor. Probation and fines and costs have long been paid and commitments completed. I want my Second Amendment rights restored. I'm getting a little old and I'd like to be able to carry and go hunting with a rifle instead of a bow. 2000, misdemeanor, non-violent carry offense, green light. I'm going to call this guy, review his case. He doesn't need to wait any longer to ask the governor for a pardon, but I can't speed up the process, and it's going to be a 2-year review. I'll cover a quick one here because with the onslaught of the internet, which has basically been since 2007, 2010, you didn't have people really before then getting charged with an awful lot of pornography. I guess there were some VHS tapes and there were adult bookstores where you could go and get tapes, but if the tape was being made, I mean, let's face it, the kind of pornography gets people into trouble is child porn. It's not adult consenting adult porn, and that's mostly what was in those old adult bookstores and such not. But since the internet came with anonymity and the ability to file share, and guys, mostly guys out there surfing for whatever their hearts desire or whatever they get looped into through addiction. So here's a girl writing on behalf of her boyfriend. We've been dating for 2 years. He's a wonderful guy. He told me over 10 years ago he had child porn charges brought against him in a county. And what can we possibly do because they want to have a family and his record's going to keep him from going to school or participating in the church nursery or going on field trips or coaching a soccer team or whatever. These cases are they're controversial for other people or maybe regular people, and everybody can get into a kerfuffle about this, that, and the other thing. To me, it's an old nonviolent offense with over 10 years of law-abiding behavior and a lot of introspection and growth that has led to a man marrying a woman, being honest with her, and trying to start a family with her. That's the kind of story that needs to go in front of the Board of Pardons. It doesn't need to go in front of me or anybody else or a jury of their peers. I think this is ripe for review. The Board of Pardons has a victim witness advocate on it. She's going to take a look at the case. She'll have 1 vote of the 5, but he has a story worth exploring and explaining and putting in front of the people that can recommend that he be forgiven. And just because it's a child porn charge and how explosive and opinionated and notorious those charges are, this isn't a charge of actually touching a child. This is a charge of looking at pictures of children under the age of 18, and you don't know what variety, I don't either, but his story is worth exploring, and those charges, there's only one way to clear them. Okay, here's a weird charge. Somebody was charged with a felony for uttered writing. This is another one of those words you only hear about in the Crimes Code or in Old English novels when you utter. And it's U-T-T-E-R. It's not, it's U-D-D-E-R, like under a cow, although I wonder if they share a common ancestry. Somebody passes a forged check, is the way you say it these days. In the eyes of the law, if you pass a forged check, you are uttering a writing to the cashier at the bank and asking for money in return. And I wonder if that means that the cashier utters cash back to you. But in any case, the uttering of a forged writing is a felony 3. I don't know that they told me the year. I'll check it out. But what we can understand is nonviolent, usually done as a crime of economic necessity, somebody trying to provide for their family, or somebody getting roped into passing checks as a way of copping drugs during a period of addiction. Regarding drug use, the board is always going to want to know how long were you using? Do you accept responsibility for your crimes? What is your clean date? How are you staying strong? How do we know that you're going to be strong in your recovery and not relapse? That's going to be their concerns. But the crime itself, uttering the forged document to the cashier in order to get money. There's nothing alarming or weird about that at all, and I think that case also deserves a good review. Just to put a pin in it, I always research records for free. If people go to recorderaser.net and they fill out the form, it comes straight to me and my team of 2 people. We research the record to see if we can find it. If we can't find it, we give you options for discovering your record or having us discover it for you. When we review the record, we can tell you what can be cleaned and when through the use of pardons and expungements. Then we give reasonable quotes for services. The pardons that take that long 2-year process, we have reasonable fees and payment plans, and the expungements, they have a lower fee, but they need to be paid all at once because they get filed within 30 days. And so go to recorderaser.net, fill out a form. I'll read your case, I'll research it, I'll tell you what I think, and I won't share your information with anyone. So that's the way it goes. Off to a great 2023. Happy New Year.